NOE Extreme Media UJ. Subscribe for all updates.
Handled for court. Yesterday we received a production warrant inviting us here, and we were never given the reason why this session had been organized by court. It's on record on Wednesday when we last appeared. Court had adjourned the matter to 29th next week. Against our honest and humble plea that please, let's have a very short adjournment, because there were pertinent issues concerning the liberty of our clients who wanted to raise. Those are issues which are canvassed under the Constitution. The issue of mandatory bail. And these are matters of law. We brought to the attention of the court this fact that our clients had spent more than 180 days on remand. And the Constitution commands that once that happens, court has no choice to release their chosen persons. And Section 76 of the Magistrates Courts Act, which reinforces the letter and the spirit of Article 23, is very, very categorical. It's clear that once the accused persons have spent 180 days on remand in matters which are exclusively triable by the High Court, no any other business should be handled by that court except entertaining the application for mandatory bail. And that is the matter we wanted to be addressed on Wednesday this week. Unfortunately, the substantive magistrate who is charged with the handling of this matter was not available, and then there was a stand-in magistrate. We requested him that please accommodate us this week so that we can make that application. First of all, he asked for Thursday. He refused. We pleaded and said probably Friday. He said please, the trial magistrate or the magistrate in conduct of this matter had given him strict instructions to adjourn it to early June, no any other date. It was by compromise that we agreed on 29th of this month, and they indicated that this week there is no date, or rather there is no space. They indicated there was no space to accommodate us this week. That was the position of the court. So in a surprising twist of events, last night they issued the criminal summons with production warrant. They issued production warrant, and shockingly, the state that moved the court to issue production warrant raised the communication which they never shared with us. That is weird. That is irregular. Because as a matter of law, they ought to have served us with a copy of the letter that moved the court to issue the production warrant for today. Even up to this particular moment we are speaking right now, we have not seen the contents of that letter. The state is holding it as if it's classified information. So when we raised these issues for the magistrate, we thought they would be serious, rather they would be accorded the seriousness they deserve. We thought the magistrate would grant us that opportunity. First of all, to make the application for mandatory bail. Then surprisingly, no, actually it's not an opportunity. Let me repeat this. We expected the magistrate to comply with the dictates of the law, that before you proceed with any other matter, first consider the application for mandatory bail. That is the law. It came as a shocker to us when the magistrate said, let the state first tell us why we are here. Meaning, even court, which issued the production warrant, wasn't aware why we are here. For us, we could not get to understand the reason why we are here from the state. It is court to tell us. It is court that issued the production warrant. So we felt we were insulted. With all due respect to the chief magistrate, you cannot tell the opposite counsel to tell us the reason why we are here, when actually it is court that summoned us. It's court that issued the production warrant. So even the magistrate was oblivious of the reason as to why we are here. And On that ground, coupled with the fact that our senior colleague was not here, because Martha Karua is the lead counsel, and there is a reason why the accused person took that decision to have Martha Karua as our lead counsel, and we wanted to work out a proper schedule, because she jetted in on, early this week, and the whole of this week had been reserved for this case. And it's the reason we asked the court, we asked the court, please, can you fix this matter either Thursday or Friday? Can you accommodate us this week for convenience purposes? Court insisted that it should be next week. So she had to go back to Nairobi. Now, immediately after she has returned to Nairobi, you issue production warrant. Are you being fair? Are you being just? So this is the rather, are you being fair or reasonable? So it's the reason we had to withdraw from the and obviously you had a statement from our client. We have not had an opportunity to discuss these matters with them, and it would be very, very unprofessional on our part to proceed under those circumstances. One, where you have no instructions, you have not discussed the matter with the client. Two, you have no idea as to which matter is going to be handled before court, and therefore you are not prepared. Let me tell you, the worst thing a lawyer can do to yourself and your client is to appear before court when you are ill-prepared. So we came here prepared to handle the mandatory bail application, not anything else, because that's the command of the law. Now the magistrate was telling us to go into something else, which was not known to us. So we had to withdraw and wait for the date that was fixed for the mention of this matter. That is 29th of this month. That's the next week. So that's when we shall be back here.
What is your take on the prosecution saying that the accuser appeared before this court on the 21st February? For you were saying that they have spent 128 days, 120 days on. What is your take on that? According to Counsel Tom Hendo, who said so that they were charged in this court on the 21st February. So the 6 months they are talking about, they are not yet. What is your take on that?
It also explains the reason why we had to walk out, because he also appeared to be ill-prepared. He was not seized with the facts. I'm sure when we come back on the Thursday to raise that application, he should not raise that vexatious argument. I don't think he was very serious about it. It would appear he is not in any way informed that actually these people have been on remand since November. It would also appear that actually he has not taken time to educate himself about all the matters concerning this case, that it has got a long history from the General Court Martial, which also issued the remand warrants, up to the time when the Supreme Court quashed the proceedings. That is the 31st January. I'm sure he hadn't updated himself about those developments.
Maybe last question. How is it important for a lawyer to represent a client in court without instructions? Because that is the ground, that is why you have to move out of the court. How important is it in the law?
It's criminal conduct. If you attempted to proceed without instructions, it's not only a professional misconduct, but it is a matter that invites criminal sanctions against you. It's criminal. You know the gravity of this matter. The sentence is death. You purport to represent somebody without instructions, or when you are not at all prepared, and inadvertently cause a miscarriage of justice that can lead to execution of somebody, taking out somebody's life, and you take that matter lightly. Not any of us here. For us, we know the implications of the decisions being made here. We know why the state is making all these machinations and maneuvers. We know what they are up to. They want to execute Dr. Besigye. They want to kill him. They have said so. This is a perfunctory process. They are just taking him through a process leading to the gallows. We cannot. We would be the last people to escort Dr. Besigye and Obedi Lutale to the gallows. Twazze wano nga tetumanyi ensonga etuleese nene tuteeka ekitiibwa mu kiragiro kya kooti kirayita production warrant ekigamba nti Dr. Besigye n'Obedi Lutale babakomyewo olwaleero. Twakoma okujja wano ku Wednesday, omusango ne gwongerwayo ku Thursday 29. Baatugamba nti omulamuzi agubeeramu teyaliiwo, yali mu meeting. Ekyatuyisa obubi. Era omulamuzi eyaliwo mujjukira bulungi abaaliwo yagamba nti mukama we eyamugambye amutulire musango yamuwadde June either nga 2 oba nga 5 talina kirala kyonna. Netwegayirira netumugamba nnyabo sebo senior counsel Martha Karua ali wano wiiki eno twagala kuorganizinga bulungi. Ekyokubiri bakiransi baffe bawezezze ennaku 18 ku rimandi ate ssemateeka mu nnyingo ya 23 ng'ogisomedde wamu n'akawaayiro namba 76 aka Magistrate Courts Act birambika bulungi ki ekiteekeddwa okukolebwa singa omuntu amala ennaku 18 ng'ali ku rimandi gy'olina okumuwa gye bayita mandatory bail. Omulamuzi yakomba kwerima n'agamba tasobola kutuwa lunaku wiiki eno. Kooti teriiwo, yagamba balamuzi tebaliiwo, bali bize wiiki eno, bali bize tebaliiwo. Naga kale munaakoma wano nga 29 netukkiriza wakati mu kunyigirizibwa. Martha Karua n'addayo e Nairobi. Ennyonyi yaddeyo akalandinga e Nairobi ate ne batuwa summons oba production warrant nti amujje kati tugenda kuwulira olwaleero. Kati wali nsonga ne tugamba okay 5 bwe baba bazze kuwulira mandatory bail application yaffe ya mandatory bail tuli betefutefu era ffe twazze tuli betefutefu okupresenting application yaffe ku mandatory bail. Ate tutuuka wano baba tugamba nti state yerina ensonga lwaki tuli wano. Twewunyiza nnyo omulamuzi naye yennyini nga tamanyi lwaki tuli wano. N'agamba nti mukkirize state yetugulire lwaki tuli wano. Kati state si yeyatuyise, production warrant kooti yeyagiyisiza. Ekyokubiri state newebanga yesaba eteekawo ensonga ez'essimba mu buwandiike neziteeka mu kooti naffe netuwa kopi nga tetunnajja wano netusobola okupripeyalinga. Kakati ebbaluwa eyo eya state oba eya gavumenti tetugirabangako n'okutuusa olwali tetunnagirabako n'ensonga ezirimu tetunnazirabako. Ebyo gye bayita trial by ambush. Lawyer yenna olina okujja mu kooti bw'obeera nga oli worth your salt, bw'obeera nga oli lawyer alimu akaniguzi, oteekeddwa okujja nga weeteeseteese. Mu butuufu twazze wano nga tetweseteese ku nsonga za state za gavumenti zeereeta kuba tetuzimanyi. Ate mu kweteekateeka olina n'okudisikasinga ne kirayanti wo. Twabadde tulina okusooka okutuula ne Dr. Besigye mugamba omanyi nno nti ekibagenda okusaba kyeki kino ne kino ne kino tukikutte tutya. Ebyo byonna tebyabaddewo. Kakati omulamuzi tubimugambye mugaffe tuli redde ku application yaffe eya bail naye ebiri ebirala ebya state tetulinaako instruction tetulimanyi ye n'alemerako. Era awulidde Dr. Besigye n'amugamba nti bano sinnabawa instructions kugenda mu maaso na bintu ebyo. Instructions za bail application. Ekyokubiri ne lead counsel Martha Karua yabadde wano nga alina special assignment gy'alina okukola mu kooti yazzeeyo. Kakati ekyo kibeera si kya bwenkanya. N'olw'ensonga eyo omulamuzi tumugamba kijja kuba kya bulabe ffe nga balooya okugenda mu maaso nga tetulina instruction ate nga tetweteeseteese. N'olw'ensonga eyo mugamba naffe bigenda mu maaso tufulumye tugenze tukulekedde abantu bo okukola kyoyagala ffe tulinze kukomawo wano nga 29.
Counsel, yogera ki ku nsonga ya statement kamago emyezi 6 gye mwogerako tekinnaba kuweramu abantu bano babaleeta mu kkooti mu nnaku z'omwezi 21 omwezi ogwokubiri naye nga mugamba nti bamaze mu kkooti oba baleetagereko
kyemmanyi kanso ky'omuhenda akyogedde abadde talina facts alabika tannamanya nti waliwo n'omusango gwa kabaziguluka alabika tannamanya nti bano baaliko mu general court martial manyi bw'anaddayo n'asoma ebintu ebyo n'arefreshinga memory ye n'akola buli kimu bwe tunaddira ku Lwokuna nga 29 tajja kukiddamu.
Kyabulabe ki ekiri mu nsonga y'abannamateeka okugenda mu maaso nga tebafunye bibuuzo okuva eri omuntu gye bakiikirira mu mateeka kiba kikosa kiteeka
omusango tugamba mu lufuutifuuti gubeera ku criminal obuzizza omusango basobola n'okuteeka wali mu kabuli okubeera impositive era gusobola n'okusazisaamu practicing certificate yo law council esobola okuwozesa ne bakusazaamu ne practicing certificate yo ate ku legal team eno njagala okubalaga omwami ono Abubeka Sekanja oyo ono mulabo ono akiikirira Uganda Law Society ku law council ekulemberwa mukyala Irene Mulyagonja bano be batuulayo ne batukangavula kakati ono y'omu ku bakangavula ba looya okumenya amateeka kati atuule wano naye agamenye addeyo eri mu law council ng'ate yalina okukangavula nedde kyalibadde kyabujega nnyo gye tuli ekyo badde tetuyinza kukikola.
Abalungi abatuwuliriza era abatulaba olunaku olwaleero tukyaddeko ewa Sheikh Ashraf Dembe.
Sebo nsanyusa okubalaba. Amannya agange nze Sheikh Ashraf Dembe akola ku bizibu by'enjawulo. Omuntu singa aba alina ebirwadde musomereddwa tumuwa amazzi ga lukuya nga bw'obadde ogalaba tugenda abantu ku kyoto ne twokya emizimu emibi egibabaamu n'okulomba edduwa abantu singa abeera ng'ali wano atuuse sobola okumulombera edduwa ne waba atatuuse nga mpadde amannya ge naye ng'ali wala neetaase enamba yange yeeno eri 0707763711 nammwe bannyinaffe abali ebweru oyagala okuba nti oyagala okulombera ku dduwa ng'olina ebizibu viza zibuze amaka gakolongotana sente zikola zimpita mu ngalo ojja kumpeereza ekifaananyi kyo n'amannya go ebyo byokka bijja kummala nja kukulombera edduwa ojja kutereera olunaku olusembayo mu mwezi mba n'edduwa eyawamu ffenna n'abalwadde bange abakadde n'abapya. Salaamu alaikum warahmatullahi wabarakatuh.